I'm a knowledge counsel in the tax department at Travers Smith. In today's podcast, one of our senior associates, Dragana Worrell, and I are going to discuss which aspects of BEPS Pillar 2 will be most relevant to asset managers. By way of a reminder, BEPS Pillar 2 is a set of interlinked rules which seek to establish a global minimum corporate tax rate of 15%. We will focus on the draft multinational top-up tax legislation, which was published on 20th July 2022 by the UK government to implement Pillar 2 into UK law. Although the multinational top-up tax will not take effect in the UK until December 2023, the rules are complex.
They certainly are, Laura. Businesses will need to consider the impact of Pillar 2 sooner rather than later. Laura, how would you suggest that asset managers begin to tackle Pillar 2?
The first issue to consider is whether or not the fund is actually within scope of BEPS Pillar 2 rules at all. Pillar 2 only applies to groups with at least 750 million euros of revenue per annum, and this is the same revenue threshold as the country-by-country reporting regime. So we would not expect a fund that is out of scope of the country-by-country reporting regime to have any obligations under Pillar 2.
Right, so what's the meaning of group under these rules? This is going to be critical.
Yes, that's a really important question. The meaning of group is an accounting concept rather than a legal test. A group is made up of the entities that are included in the consolidated financial statements of the top entity in the group. That entity is otherwise known as the ultimate parent entity. The consolidated financial statements must be prepared under an approved accounting standard. There's also a deemed consolidation test. The purpose of this test is to deem entities to be consolidated where there are no consolidated financial statements, and had such statements been drawn up, the entities in question would be consolidated. The wording of the deemed consolidation test is not clear, and this has led to concern that it might deem entities to be consolidated even where they actually use an approved accounting standard and, under it, are not required to be consolidated. But this is not what the test is intended to do, and we understand that guidance is being drafted by the OECD Secretariat to clarify this point.
That will be welcome news to many in the asset management industry who have been concerned about this point.
Absolutely. So, to reiterate, the group will only be made up of those entities that are required to be consolidated on a line-by-line basis under an approved accounting standard. We would expect that most funds will not be required to consolidate their investments. If a fund has not consolidated its investments, it will only be within the scope of Pillar 2 if the value of a standalone investment is 750 million euros or more. Let's look now at the issues which will be relevant to those funds which are in scope. One of the key things to consider is whether the fund vehicle and its holding companies qualify as excluded entities.
Yes, being an excluded entity is important because excluded entities do not have to do an effective tax rate calculation and are not liable for top-up taxes under either the income inclusion rule or the undertaxed profits rule. The list of excluded entities has what you would typically expect to be excluded. For example, government entities, international organizations, non-profit organizations, and pension funds. However, also included within the list are investment funds and UK REITs or overseas REIT equivalents, in each case, which are the ultimate parent entity of a group. These entities are excluded from Pillar 2 in order to protect their status as tax-neutral investment vehicles. It's worth noting that the latter two categories, so UK REITs and their overseas equivalent, represent a slightly different approach to that set out in the OECD model rules, which instead have the concept of a real estate investment vehicle. There were some concerns about how UK REITs would fit into that definition, and so the UK's approach effectively sidesteps that issue. We will talk about what it means to be the ultimate parent entity in a minute, but let's have a look at what is required for a fund to fall within the investment fund definition. There are 7 criteria to be met. The relevant entity must meet the following. That is, it must be designed to pool assets from a number of investors, some of which are not connected. It must invest in accordance with a defined investment policy. It must allow investors to reduce transaction, research, and analytical costs or to spread risk collectively. It must be primarily designed to generate investment income or gains or protection against a particular or general event or outcome. Investors must have a right to return from the fund's assets or income earned on those assets based on the investor's contributions. And the entity or its management must be subject to a regulatory regime in the jurisdiction in which it is established or managed, including anti-money laundering and investor protection regulation. And finally, it must be managed by investment fund management professionals on behalf of the investors.
Ragnar, in a typical fund, would you expect then that most of these criteria would be met?
Yes, but some points might present more of a challenge, and this is where further clarification would be welcomed. For example, let's take the first limb. The fund needs to be designed to pool assets from a number of investors. We understand that funds which have at least 2 investors should satisfy this test, although it would be useful if this could be confirmed in guidance. The requirement for multiple investors may be problematic where a fund sets up a parallel vehicle, for example, to accommodate the needs of a particular investor, such as being blocked for US tax purposes. The parallel fund vehicle will be considered in its own right and not together with the main fund. And as it will have been designed to have only one investor, it will most likely fall foul of this criteria. This could have a knock-on effect on the excluded entity status of holding companies used by the fund structure if the parallel vehicle has a significant interest in these vehicles. Now, another criteria that would merit further clarification is Lim 5. That is, that investors have a right to return from the fund's assets or income earned on those assets based on those investors' contributions. This would generally be true, but a fund will typically be structured to provide for an enhanced return to the fund managers if the fund performs well in the form of carried interest. The amount contributed by fund managers for their carried interest will generally be quite minimal. And in addition, there will often be a period of time where the fund managers will be entitled to, for example, all the profits of the fund until they have effectively caught up on their carried interest with external investors. In both of these cases, the fund managers would technically be receiving a proportionately greater return on their investment than other investors. Similarly, if a fund is structured to have a significant priority profit share, for example, to then fund the management fee, this too could potentially be an issue.
Yes, I can see how these could be problematic, as it is quite common for funds to have such parallel vehicles or priority profit share fee structures, as well as some form of carried interest for the fund management team.
Exactly, and so it will be important for the rules to clarify the position on single investor parallel vehicles, but also that the presence of carried interest or a priority profit share in a fund structure will not deem the fund not to be an investment fund. So as you can see, Laura, there are still some elements with respect to the investment fund definition that need to be ironed out. However, as mentioned, if a fund does meet these criteria and is the ultimate parent entity of the group, then it should be an excluded entity and so not subject to obligations under the BEPS Pillar 2 rules. Now, Laura, we've looked at the fund vehicles themselves. What about the entities used by investment funds to hold their investments? Do you think that they will be excluded entities?
Holding companies will be excluded entities if they are 95% or 85% owned by an excluded entity in the list that you've just referred to and satisfy an activity test. But the main problem with this definition in the OECD model rules is that in order to be an excluded entity, the investment fund needs to be an ultimate parent entity. An ultimate parent entity is an entity that holds a controlling interest in another entity. That is to say, the entity is required to consolidate the assets, income, etc. of the other entity on a line-by-line basis.
This will be a problem then, because most investment funds won't be required to consolidate their investments or the holding companies through which they hold their investments.
Yes, that's correct. Although we understand that there was never any intention to distinguish between holding stacks owned by investment funds that produce consolidated accounts and holding stacks owned by investment funds that do not produce consolidated accounts, it seems that there is currently an issue. Whilst this problem appears to have been largely solved in the UK's draft multinational top-up tax legislation, this can only be part of the solution.
Yes, we'll need other jurisdictions to follow suit.
So those are the key initial issues to be considered by in-scope funds. Asset managers, of course, will need to also think about how the rules will impact their investments and in which entities it is most desirable to pay any top-up tax liability. But what about funds that are not in scope? Can they ignore BEPS Pillar 2?
Unfortunately, no. It will be really important for asset managers to become familiar with the BEPS Pillar 2 rules and how they may operate in practice. Where a fund invests into a target group that is itself within scope, even where this is a minority investment, then if the entities within that target group are subject to top-up taxes, this will obviously affect their profits and therefore the returns that are available to the fund. Asset managers will need to understand the rules and be able to model how returns to investors might be impacted as a result of any top-up taxes levied within the target group. In addition, as part of their due diligence process on a potential investment, it would be good for managers to stress test how ready the target group is to deal with BEPS Pillar 2 and how the group anticipates that its profits might be impacted.
Interesting. We hope that you've enjoyed listening today. You can find more materials on BEPS on our tax department page on the Travers Smith website.